The Supreme Court handed down a stern rebuke to some of the most right-wing judges in the country on Wednesday, holding that no, judges do not get to micromanage how the Biden administration speaks to social media companies. The vote in Murphy v. Missouri was 6-3, with Chief Justice John Roberts and Justices Brett Kavanaugh and Amy Coney Barrett joining the court's 3 Democratic appointees in the majority. Justice Samuel Alito dissented, joined by Justices Clarence Thomas and Neil Gorsuch. As Barrett's majority opinion lays out, this lawsuit never should have been filed in the first place, and no federal court should have entertained it. Her opinion holds that the Murphy plaintiffs, who raised vague allegations that the government tried to censor them, could not even show that the government did anything to harm them in the first place. Murphy involves a wide range of communications among the White House, various federal agencies, and major social media platforms like Facebook and X, the website formerly known as Twitter. Some of these communications urged platforms to remove content, such as speech seeking to recruit terrorists to spread election disinformation, or to promote false and potentially harmful medical advice, including false claims about COVID-19 and vaccines. The plaintiffs in Murphy are to red states, plus an array of individuals who had content removed or suppressed by at least one of the social media platforms. They claimed that platforms censored them because of pressure from the government, and that this pressure violates the First Amendment. That is a highly dubious claim. While the First Amendment forbids the government from coercing media outlets into removing content, nothing prevents the government from asking a platform to do so. Indeed, at oral arguments in Murphy, both Justices Elena Kagan and Kavanaugh recounted times when, during their service as White House officials, they pressured journalists to remove or correct editorials or other content that contained factual errors. Nevertheless, the far-right U.S. Court of Appeals for the Fifth Circuit did not simply embrace this claim. It issued a vague and sweeping injunction forbidding the Biden administration from having consistent and consequential communications with social media companies, whatever that means. As a practical matter, this difficult-to-parse injunction made it virtually impossible for the administration to have any communications whatsoever with the platforms. But the Supreme Court held that the Fifth Circuit was wrong to even consider these plaintiffs' dubious First Amendment arguments, ruling that federal courts lack jurisdiction over this case. Why the Supreme Court tossed this case out? In order to file a federal lawsuit of any kind, a plaintiff must show that they've been injured in some way by the defendant, a requirement known as standing. As Barrett lays out in her opinion, this standing requirement has several components. Among other things, a plaintiff must show that the defendant's actions actually caused their injury, and that the injury is redressable by a court order, meaning that the court could actually do something to fix the damage allegedly caused to the plaintiff. Additionally, when a plaintiff seeks an injunction, a court order requiring the defendant to change their behavior in the future is not enough to show that the defendant harmed the plaintiff in the past. Rather, as Barrett writes, the plaintiff must show that it is likely the defendant will cause them the same harm in the future. Notably, these plaintiffs sued the federal government, and not the platforms themselves, for the platform's decision to remove or demote some of the plaintiff's content. That decision, to target a defendant with only an attenuated connection to the alleged censorship, made the Murphy plaintiffs' case even weaker. Indeed, some of their claims that they were injured by the government were embarrassingly thin. One plaintiff, for example, claimed that Twitter suspended his brother's account in response to pressure from the FBI. But even setting aside the lack of evidence that the FBI played a role in Twitter's decision, a plaintiff does not have standing to sue if their brother was harmed. Only the brother may file such a lawsuit. The court did find some vague links between Facebook's decision to moderate content by one of the plaintiffs, an anti-mask and anti-vaccine mandate activist named Jill Hines, and the government's actions. Facebook deleted one of Hines's posts 3 months after a White House official suggested that the platform should end group recommendations for groups with a history of COVID-19 or vaccine misinformation. And Facebook warned Hines against reposting content from a particularly notorious anti-vaccine advocate, third-party 2020 for presidential candidate Robert F. Kennedy Jr., 2 years after the White House included Kennedy on a list of prolific spreaders of COVID misinformation. But as Barrett writes, these links are weak. Facebook was targeting Hines's pages before almost all of its communications with the White House and the CDC, which weakens the inference that her subsequent restrictions are likely traceable to government-coerced enforcement of Facebook's policies. And even if the links were stronger, Hines can't show that she will face future injury because of the government's actions. Among other things, Barrett notes that the Biden administration has largely halted its efforts to persuade social media platforms to remove COVID misinformation now that the acute phase of the pandemic has ended. So even if Hines could somehow show that some of her content was removed in the past due to government pressure, she has no reason to believe that it will be removed in the future due to similar pressure. The Fifth Circuit is a rogue court. It's notable that 3 Republican justices, including 2 Trump appointees, joined the Murphy majority. This is less a sign of those justices' moderation than it is a response to an increasingly partisan Fifth Circuit. The Fifth Circuit, which is dominated by far-right judges, routinely hands down decisions that no reasonable judge could support, and the Supreme Court spends an increasing amount of time correcting these decisions. Earlier this term, for example, the Supreme Court reversed the Fifth Circuit's declaration that an entire federal agency is unconstitutional. It also reversed the Fifth Circuit's holding that domestic abusers have a right to own guns, although, in fairness, the Fifth Circuit's decision in that case was more defensible under the justices' own incompetently drafted opinion in the 2020 case, New York State Rifle Pistol Association v. Brune. The Fifth Circuit's order in Murphy fits this pattern. That court took a bunch of vague allegations involving decisions by private companies that had only a tenuous connection to anything done by a government official, and used those vague allegations to try to shut down the Biden administration's ability to communicate with those companies. Barrett even faults the Fifth Circuit and the right-wing trial judge who first heard this case for misrepresenting many key facts. In her words, the Fifth Circuit relied on the district court's factual findings, many of which unfortunately appear to be clearly erroneous. For the moment, at least, the Supreme Court appears to be holding the line against this uniquely partisan court, but it is far from clear that this line will hold if Trump wins the 2024 election. Murphy, after all, was a 6-3 decision. So, if Trump gets to appoint 2 more justices, the Fifth Circuit's values could soon be imposed on the entire nation. And also, for the second time in 2 years, a major Supreme Court abortion decision leaked before the justices officially released it. This time, however, the most likely explanation is a clerical error by someone who manages the court's website. 2 years ago, an early draft of Justice Samuel Alito's opinion in Dobbs v. Jackson Women's Health Organization, the case overruling Roe v. Wade, leaked to the press. The identity of the leaker remains unknown, as does the leaker's motive. About 2 months after the leak, the Supreme Court released its final opinion in Dobbs, which was substantially similar to the leaked draft. On Wednesday, another significant abortion opinion leaked, although this time the leak appears to be an accident. According to Bloomberg, the justices' opinions in Moyle v. United States were briefly posted on the court's website before being taken down. A Supreme Court spokesperson said that the court's publications unit inadvertently and briefly uploaded a document to the court's website and that the final decision will be issued in due course. Bloomberg posted the text of the leaked document at this link. Moyle asks whether states can ignore a federal law which requires most hospitals to provide emergency care to patients who need it, including abortions, if that is the appropriate medical treatment. Specifically, whether Idaho's near-total ban on abortions prevents doctors from providing medically necessary abortions. Assuming that the leaked document resembles the court's final decision, a majority of the justices have decided not to decide the Moyle case, though the court has seemingly splintered into 4 separate concurring and dissenting opinions, none of which garnered a majority of the justices' support. 5 justices apparently decided that the court was wrong to take up this case using an expedited process that bypassed an intermediate appeals court. The leaked document does contain some good news for abortion rights advocates. Last January, the court temporarily blocked a lower court decision, which held that the state of Idaho cannot enforce its strict abortion ban against patients who need an abortion to save their life or to ward off catastrophic health consequences. In the leaked document, 6 justices voted to reinstate the lower court's order, at least for now, which means that Idaho patients who require medically necessary abortions will no longer need to be airlifted to other states. Still, the primary effect of the decision, assuming it closely resembles the leaked draft, will likely be to punt the final resolution of this case until after the election. That means that patients outside of Idaho who may have been hoping a decision in this case would set a precedent requiring doctors across the country to follow the federal law requiring care in the event of an emergency, may not be able to obtain abortion care that they need to save their life or to ward off very serious health consequences. What's at stake in Moyle? The Federal Emergency Medical Treatment and Labor Act EMTALA requires all hospitals that accept Medicare funds, which is nearly all hospitals, to provide such treatment as may be required to stabilize the medical condition of any individual who arrives at the hospitals with an emergency medical condition. EMTALA, moreover, defines an emergency medical condition to include not just conditions that threaten a patient's life, but also conditions that risk serious impairment to bodily functions, or serious dysfunction of any bodily organ or part, among other things. Thus, if a patient's uterus would be destroyed if they do not receive an abortion, EMTALA generally requires hospitals to provide that abortion even if the patient is likely to survive without it. This federal law conflicts with an Idaho statute, which bans all abortions except when necessary to prevent the death of the pregnant woman. When a federal law conflicts with a state law, the Constitution provides that the federal law shall be the supreme law of the land, and thus the state law is preempted. EMTALA also contains a provision stating that state and local laws must give way to the extent that the state law directly conflicts with a requirement of this section. So this should be an easy case. EMTALA imposes a broad requirement on nearly all hospitals to provide emergency care, and it does not include an exception for abortions. The statute, moreover, explicitly says that state laws must give way when they directly conflict with EMTALA. But, in this court, nothing involving abortion can ever be easy. How Moyle seems to have divided the justices, the court's three Democratic appointees, Justices Sonia Sotomayor, Elena Kagan, and Ketanji Brown Jackson, all argue into separate leaked opinions that EMTALA means what it actually says, though they appear to have split on a procedural question. Ordinarily, the Supreme Court waits until at least one appeals court has weighed in on a case before taking it up. In Moyle, however, the court invoked an unusual process, known as certiorari, before judgment to bypass the appeals court that was supposed to hear this case. Kagan, joined by Sotomayor, argues that the case should be sent back to the appeals court that should have heard Moyle in the first place. Jackson, meanwhile, argues that the court should rule immediately that EMTALA means what it says. As she writes in the documents Bloomberg published, doctors observing the different legal thresholds for action under state and federal law will surely be cowed into not providing abortion that is required by federal law, especially because of the risk that they could be prosecuted under state law. A decision by the Supreme Court holding that EMTALA trumps state law would allow doctors to perform medically necessary abortions with certainty. At the court's rightward extreme, Alito, in a leaked opinion joined in whole by Justice Clarence Thomas and in part by Justice Neil Gorsuch, argues for an abortion exception to the EMTALA statute. Alito primarily points to several provisions of the law, which use the phrase unborn child. These provisions primarily require hospitals to offer stabilizing care to a pregnant patient's fetus, suggesting that a statute which uses that phrase must not be read to permit abortions. Alito also makes a novel constitutional argument, claiming that the state of Idaho must consent before its abortion ban can be preempted by EMTALA. That leaves Justice Amy Coney Barrett, writing for herself, Chief Justice John Roberts, and Justice Brett Kavanaugh in the middle. Barrett's opinion, as it's published in the Bloomberg leak, leaves nearly every important question raised by Moyle unresolved. She agrees with Kagan that the case should be sent back down to the lower court, thus creating a majority for that result. And she writes that Alito's constitutional argument is difficult and consequential without taking a position on that argument. The thrust of Barrett's opinion is that there is no longer a need to bypass the appeals court and decide this case on an expedited basis because of concessions made by lawyers on both sides. The Biden administration, which argues for EMTALA to be read according to its plain text, conceded that EMTALA could not be used to authorize abortions because a patient has a mental health condition. And it also conceded that federal laws permitting hospitals or doctors with moral objections to abortion to opt out of providing them still apply even under EMTALA. Idaho's lawyers, meanwhile, claimed that its state law permits abortions for some medical conditions, even if the threat to the woman's life is not imminent. According to Barrett, the parties' positions are still evolving in this case, and thus it makes sense for those positions to be refined in a lower court before the Supreme Court has the final word. So the good news for abortion rights supporters is that emergency room patients in Idaho will have the full benefit of EMTALA, at least while this case is working its way through the appeals court and back up to the justices. The bad news is that the leaked Moyle decision does nothing to help those same patients in the other 49 states. And that's a serious problem for abortion rights generally. As Jackson notes in her opinion, One problem that's emerged since Dobbs is that, while even the most anti-abortion states typically permit abortions in some cases, such as if the life or health of a patient is threatened, there are often no court precedents explaining when abortions are allowed and when they are not. That means that doctors cannot know, and their lawyers cannot advise them on when it is legal to perform a medically necessary abortion. And that has created a reality where those exceptions are exceptionally difficult, in some states, nigh impossible to qualify for. As my colleague Nicole Naria reported, Kate Cox, a Texas woman, was notably denied an abortion even though her fetus was diagnosed with a rare and terminal genetic condition and forced to travel out of state to obtain one. Other women have been forced to carry to term fetuses doctors know will die shortly upon birth, or been denied abortion care even after experiencing a miscarriage that leaves them in medical distress. The Texas Supreme Court also ruled against a group of 20 women who claimed that they had been denied medically necessary abortions. The Moyle lawsuit was an effort to solve this problem by allowing federal courts to develop precedents stating when EMTALA creates a right to an abortion. But that process cannot begin until the courts agree that EMTALA means what it says. Thus, if the leaked Moyle decision proves to be authentic, that means it may be months or even years before the federal courts can start generating the precedents that hospital lawyers need to advise their clients, and that's assuming that Alito doesn't ultimately have the votes to write an abortion exception into EMTALA.